Thank you. All right, let's proceed. Good morning.
Thank you. Good morning, and may it please the court. My name is Ryan Schiff, and along with Stephanie Stolk-Ormsby, I represent the juvenile. In response to a motion jointly filed by the juvenile and the Commonwealth, the court below found that the juvenile, despite having committed a sex offense, posed no risk of reoffense and no danger to the public. The judge nonetheless required that the juvenile wear a GPS monitor around his ankle for the entire period of his probation because she concluded that the monitoring was mandatory under Section 47 of Chapter 265.
Could you go to the statute, 265, Section 47? I think that the reason that the judge did what she did is because it starts out by saying any person who's placed on probation for a set of listed offenses, sex offenses, shall, as a requirement of any term of probation, wear a GPS device at all times for the length of his probation for any such offense. Now, I know that you make arguments regarding other language in the statute and the purpose and the history, the legislative history, but ordinarily we look at the plain language of a statute and don't get to the other things if the language is plain. And I'm wondering what is not plain about any person. Is a child, a juvenile, not a person?
Of course, a juvenile is a person, and of course the language is broad. However, this court in Raposo just 3 years ago interpreted this exact same language and looked at the legislative history, which is also a well-established canon of statutory construction, and determined clearly that this applied only to people who had been convicted of sex offenses.
Did anybody in Raposa, I can't remember this, make the argument that, because that was a question about pretrial versus
Yes,
probation as some form of sentence. Did anybody make the argument that the statute didn't apply at all, as you are making here, to juveniles?
To juveniles? I don't believe that issue came up.
It wasn't Raposa, it was Emilio.
Emilio E.
Yeah.
was the companion
Right.
case. The decision is very brief in that. And as far as I know, that argument was not made
I didn't remember
in that
it being
case.
made either. I
That's
didn't
correct.
know if I
And-
was...
Yeah, and of course, juvenile delinquency adjudications, as the Commonwealth concedes at page 19 of their brief, are not convictions under well-established law of this Commonwealth. So the other side has really no good response to how their position can stand in light of Raposo. The best that they do is to say that this court in Raposo was carelessly using the language convicted loosely to mean post-judgment rather than actually convicted. But that ignores the details of what this court actually did in Raposo. This court looked at the details of the legislative history and found that the original bill that resulted in Section 47 specifically limited it to convicted individuals, but then was unclear about whether that applied to probationers or parolees, and whether institutionally it was the parole board or whether it was the commissioner of probation who is to supervise these people. And by adding that language about any person placed on probation, this court found, the legislature was not expanding the reach by any means of that, but still limiting it to convicted people, but making it clear which convicted people it applied to and what agency within the Commonwealth was responsible for supervising these people.
With respect to this particular probation, were there conditions placed that were in keeping with the conditions required under Section 47?
In terms of geographic exclusions?
Including from a school?
There were not, and I think that actually is an additional reason to think that this does not apply to children. It does make sense for many adult probationers who've been convicted of sex offenses to think that we don't want them going places where children congregate.
Well, but what about? I mean, if the circumstances of this case were very different, if this was a rape that involved people who didn't know one another, it had actually been consummated, there were acts of violence involved, and the defendant had been adjudicated, I mean, the legislature would not be concerned that a person that had committed those acts should not be monitored by a GPS bracelet?
I think, of course, the legislature would be concerned about those people. And we don't contest that under the right circumstances, a juvenile court judge does have the discretion to impose GPS monitoring.
On an individual basis.
On an individual basis. And it just has to conform with normal constitutional standards if it affects a constitutional right, as the Commonwealth concedes. So it has to be reasonably related to the goals of probation. And then we also, in our brief, talk about how this being a search and seizure, there are search and seizure considerations. I'm not sure that that standard is really, quite frankly, all that different than the reasonably related test.
Well, what if this were not a juvenile case, but an adult case, a 17-year-old adult, committed exactly the same acts that were committed here? That person would have to wear a GPS bracelet just by virtue of being an adult, and you would still be making very compelling arguments, exactly the same arguments.
Yes, Your Honor, we would be making the constitutional arguments. Of course, the first argument about statutory construction, juveniles wouldn't apply. But our last two arguments about the constitutional problems with imposing GPS monitoring on somebody who poses no risk of reoffense and no danger to the public would still be there.
Is there any difference? I mean, you say here that the judge made a finding under Chapter 6, Section 178E, subsection F, which is relating to the not posing any risk of a reoffense or a danger to the public. Is that finding now has to be made before probation is imposed? Isn't that right?
I believe that's correct, Justice Lang.
Do they serve? I mean, is that the kind of finding that is really the same thing as saying the juvenile doesn't have any risk of reoffending, or is of absolutely no risk to the public right now? And if that's true, why is probation appropriate? I mean, as opposed to if the juvenile has absolutely no. It's found to be of no risk to anyone. What purposes is our probation going to serve in the first instance?
Well, I do think that is, in general, a good question. There is no, of course, any constitutional requirement for ordinary sentencing, like placing somebody on probation, that it serves a purpose. Where that analysis comes in, and where you have to there has to be a showing that there's a reasonable connection, is where probationary conditions are imposed that affect or infringe on constitutional rights, which GPS monitoring plainly does.
One could posit here that a judge could determine that there was no risk of having a sexual reoffense, but still believe that the juvenile may be in need of some monitoring and guidance because whatever else might be said, it was inappropriate behavior.
That is absolutely correct.
And so probation may well be appropriate. And it wasn't a very long probation to begin with.
That's true. And of course, the purpose of the juvenile court is not to punish children, not to treat them as criminals, but to ensure that they get the services they need and to ensure their care and protection. So the judge certainly could look at his entire situation and say, probation is needed. He needs some guidance. He needs a probation officer to check in with to make sure he's getting whatever services he needs. And I think just the fact that he committed this act makes it reasonable to say, well, that if probation deems it necessary, that he ought to get treatment, which was a condition, and a condition that we in no way challenge.
But you would say no GPS.
Absolutely, we would say no GPS, because in order for that condition to be legitimate, there has to be some reason, this is under the constitutional standard, for some purpose that it serves. It has to be reasonably related to the goals of probation.
Let's assume this finding with respect to registration hadn't been made. Are you suggesting that the legislature could not conclude that someone convicted of one of these offenses, that it was reasonable to require GPS condition of probation, that somehow that's unreasonable per se, without an individual assessment in every case?
So the question, I don't think, is whether the overall global assessment by the legislature, whether this category of offenders need to be on GPS, is the right one. This court has never held, and I'm aware of no other court in any other jurisdiction, holding that the legislature can do away with the constitutional requirement that these kinds of conditions be reasonably related to the goals of probation
Well, they have
in
made
an
the
individual.
the legislature has made the judgment that they are.
That's correct.
For
But
purposes of protecting the public. You mean the legislature simply cannot make that judgment? GPS is so specially different, they can't make that judgment?
on a global scale, I don't think that they can. But this doesn't mean that the statute falls altogether. It's just that as applied to individuals where it serves no legitimate purpose or it isn't reasonably related to the goals of probation, that it can't be imposed. And I think yesterday the appeals court had a very thoughtful decision in Doe versus Parole Board that looked at a statute giving the parole board unbridled discretion to set conditions of parole. And the appeals court looked at that in terms of GPS monitoring and said, that has to be read in relation to the constitutional requirement that parole conditions, like probation conditions, be reasonably related to the goals of supervised release. And that's what we're asking in our constitutional argument, if you reach it.
I'm sorry, I don't mean to interrupt you.
No, please
I'm
go
back
ahead.
on the statute.
Yes.
The last part of this statute talks about if somebody violates this under 279 Section 3, either the commissioner of probation or the probation officer can immediately grab the person. And so I looked at 279.3, and I must say, as I read it, it didn't seem to me that it is a statute that gets used for juveniles. But so that's my question. Is it? As a practical matter, does it apply to? I just couldn't tell.
I'm not sure if that statute applies to juveniles, quite frankly, Your Honor. I didn't look at it before this argument, but I think
What happens when, or is there a statute in Chapter 119 that covers what happens when a juvenile violates probation and somebody wants to snatch him or her because of that?
Well, my understanding is that the juvenile will be given notice to appear in court, and then is a violation.
There's no
proceeding
specific
goes forward.
there's no specific section in Chapter 119.
Not that I'm aware of.
I have a question for you. It's a big picture question. By analogy, could the legislature say, for example, that all offenders who possess a gun should get a mandatory sentence? And if they can say that, what if they have a juvenile who the testimony is they'll never pick up a weapon again, there's no risk of reoffending? Would you say that the juvenile could not receive that mandatory sentence?
I do not say that, because there is no precedent that would support the argument that a term of incarceration, say, or a term of commitment that is mandatory has to in any way be related to the goals of sentencing. But there is a clear requirement that this court has recognized repeatedly, I believe most recently in the Goodwin decision, that where probationary conditions affect constitutional rights, they do have to be reasonably related to the goals of probation. But this statute, however, I do think that on just the question of whether this even applies to juveniles, that question has to be answered that it does not. In Raposo, you were looking at pretrial probation, and you concluded that the statute only applies to convicted individuals and therefore didn't apply to pretrial probationers. If anything, we would expect the legislature to be more explicit when if they wanted this to reach juveniles.
But the statute, it seems to me, is designed to be protective of society as opposed to purposefully limiting geographic areas of juveniles or even adults, for that matter. I mean, the GPS really, in these circumstances, is designed to protect members of society. And are juveniles exempt from that concern?
Juveniles are certainly not exempt from that concern. But what this court has made clear and what the legislature has repeatedly made clear is that juveniles have to be treated differently than adult criminals. In Magnus M., a case that this court decided earlier this year, this court reaffirmed the principle that juvenile court judges have to have very broad discretion to determine what kinds of dispositions are required or called for by any individual case. And by applying this statute to juveniles, it would take away that discretion that is so well rooted in our juvenile justice system. So if the legislature had intended to do that, we would expect them to at least be as specific as they would be when talking about pretrial probation.
If I may just follow up on the earlier question I asked you, the hypothetical about the juvenile who's convicted for possession of a gun, we do have a case here that says that a second conviction for that is to be treated as a conviction.
That is true. Connolly C. did say that, but at the same time, the court emphasized on the last page of that decision that it was a narrow decision that applied only to that specific statutory provision, and that it was in no way altering the general rule.
By analogy, if that's to be treated as a conviction, it would seem to me we might also reach that conclusion in this situation.
But in that case, however, the statute did not make any sense unless the court could treat it as a conviction. And the court made clear while doing that it was not changing the general rule, which has been repeated again and again earlier this year in Commonwealth versus Anderson said it, and even in the youthful offenders context, that a juvenile delinquency adjudication is not a conviction. I see my time
Counsel,
is up.
your time is up. Thank you.
Thank you.
Good morning, Your Honors. Catherine Robertson from the Hampden District Attorney's Office on behalf of the Commonwealth. With respect to the application of the statute to juveniles, the application of Chapter 265, Section 47 to juveniles, the statute uses the words, any person placed on probation. Any person is a broad term. It's like the person whoever that this court determined in the Valentin case applied to juveniles as well as to adults.
Well, what do you say about the Raposa case, where we took the same language and looked to legislative history instead of looking just at plain language?
I would say two things about the Raposa case, Justice Lang. The first is that the question really wasn't posed to the court in Raposa whether or not the statute applied to juveniles as well as to adults. That was not the issue that was in front of the court. It was post-conviction.
But there was still a looking at the statute to
Still
see whether
looking-
any
right.
person, which would presumably include pretrial probationers as well as convicted people, was seen as not including one of those. So it wasn't really any person. What I'm saying is, you've got the same language, and we're doing something other than looking at it as just, the plain language.
Let me point out that the Raposa case does say in footnote 10 that there was an exception to when the parole versus probation sections were split up. There was a change to the language in the probation section. There was a change, and the change to the language in the probation section was that the term convicted individual was replaced by the term offender. And the legislature is presumed to understand or to know the uses that have been made in other statutes and in other cases of terms. And the term offender has been used to apply to juveniles who are adjudicated delinquent by reason of various criminal.
But Ms. Roberts, it doesn't, at least in the examples you gave, the word offender was always preceded by juvenile offender. The phrase, juvenile offender.
Yes, I think that's probably accurate, Your Honor. It was always, but the term offender, nonetheless, has been the term sex offender, Your Honor. The term sex offender, which appears in the title of this act, by definition, extends to a juvenile who's adjudicated delinquent by reason of a sex offense.
Because even in that same statute, there's a conviction as compared to adjudicated as a youthful offender or as a delinquent juvenile, distinguishing between conviction.
And the term conviction nowhere appears in Chapter 265, Section 47, Your Honor. There is no reference to a conviction. There is only there's a reference to an offender, there's a reference to a probationer, and there's a reference to any person. There's no use of the term conviction anywhere in Chapter 265, Section 47. It doesn't use the word, and that's really why the Commonwealth has said that there are many ways in which the legislature could have been clear about an intention to exclude juvenile offenders from the reach of.
Wouldn't you think, given the whole history of the juvenile development of juvenile law, that if the legislature intended that they would say so specifically?
I guess I would reverse that and say that if they had intended to exclude juveniles from a term that's as broad as any person,
That's what I'm asking.
could
I
have
guess
done
it's a
that.
question of
But-
which would
well,
they have done.
Sure, but the other thing is, I think that if you look at the entire scope of statutes that apply to sex offenders, and again, I'm relying on the definition of a sex offender. The definition of a sex offender has included a juvenile adjudicated delinquent by reason of a sex offense since at least 1996. That's at page 5 of the Commonwealth's appendix. The registration obligations apply to juveniles just as they apply to adults. So generally, and if you look at the act, the specific act in which Section 47, Chapter 265, Sections 47 appears, there are other sections of that act that encompass provisions that apply to juveniles. So I think it's an uphill battle for the juvenile to say that Chapter 265, Section 47 doesn't apply to juveniles based on the language of the statute, the use that the legislature has made of these terms, the definition of sexual offender that is consistently used by the legislature.
Is there another provision in the statutory scheme where we imply an application to juveniles absent a specific indication within the language, as the language I just pointed out to you, that says convicted of or
Adjudicated
juvenile, the two, yeah, just any
There-
person applies, and then we always say, well, of course, we also mean juveniles.
I'm not sure I can answer that question the way it's
Unusual.
phrased. I'm not sure I can answer that question. I will say that this section has no definitions the way much legislation includes, a list of definitions. There's no list of definitions here. I guess I would go back to the fact that the title of the act does refer to sex offenders, of this specific section of the act refers to sex offenders, and that the definition of a sex offender does include somebody who's adjudicated delinquent by reason of a sex offense, a juvenile adjudicated delinquent.
Now, turning to legislative intent, there is a sentence in the same statute which speaks about the obligation of the Commissioner of Probation to establish defined geographic exclusion zones, which are to include schools, and, quote, other areas defined to minimize the probationer's contact with children. Should we assume that a legislature which was intended to apply this provision to children would include a provision for exclusionary zones that would bar the child from going to school or from having contact with children?
That provision, Your Honor, goes on to say, if applicable, and the Commonwealth's interpretation of that provision would be if the court was faced with somebody who had committed an offense against a child, that the exclusion zone would be established by the probation department, excluding contact with children, if the offense was one that was really an offense against a child. Now, I know that this juvenile was adjudicated delinquent by reason of a sex offense against another child, but he was 15 at the time. It was a classmate. I believe, the probation department, I think, would be unreasonable in excluding a child from attending school.
But doesn't that argue precisely against your point? Because the very nature of a child offender committing an offense against a child is that it's going to be two children engaging in sexual conduct, which could be consensual and nonviolent apart from the fact that they're incapable of giving consent.
Or could be violent.
But put aside that, I mean, the fact of the matter is 2 12-year-olds experimenting with sex now are viewed as sex offenders, and would therefore be obligated to have the GPS, and arguably could be excluded from schools or from other contact with children. And your point is that the legislature meant to do that?
I believe meant to give the probation department discretion to establish appropriate exclusion zones in appropriate cases, Your Honor, which would not include an exclusion zone for a school or for other areas where a child can go.
So then what would it be meant to exclude if it's a child? What are you preventing the child from
Contact with the victim, Your Honor, clearly. I mean, the exclusion zone in any case, or according to the statute, in any case, the probation department is to establish an exclusion zone that prevents the child from having, from going near the victim's residence, the victim's place of employment, or the victim's school.
Okay, but of course that could, I mean, even if you lose here, that could still be done where it's deemed appropriate by the particular juvenile judge. But you're saying that would be intended in all instances, that the legislature meant for this to happen, even though it speaks about exclusionary zones for children as if we're referring to adults?
I believe that is the intent of the statute, Your Honor, and that particular provision, establishing an exclusion zone for areas that would bring the probationer in contact with children, if applicable, is intended to cover the situation where the probationer in front of the court has committed an offense, is a pedophile, essentially, Your Honor, and has committed an offense that makes it appropriate to limit.
It's committed an offense against a child.
I understand that committed an offense against a child applies in this case, but I believe that the probation department has the discretion to establish appropriate exclusion zones, and that when you're dealing with two children and the offense is between two, like-aged people, and of the nature of the offense in this case, that it would not be appropriate to establish, it would not be intended to, the legislature would not intend the establishment of an exclusion zone that prevented this child from going places where he or she would be in contact with other children.
You could just, I guess, step back. We assume the legislature is using common sense and good sense. Would it be good sense to say that whenever any child commits an offense involving another child, regardless of whether force is used, that we would want, that the legislature would have meant and intended that they have to wear a GPS for whenever their conduct is not severe enough to warrant incarceration, but is not severe, is warrants probation? I mean, is that something we should intend a common sense legislature to have done?
I think that's what the language of the statute
Right. I'm referring
says.
to whether that's what they meant, whether we should infer that that's what they have meant to do. We have other times taken language, and Halebian versus Burr is a recent example, where we said that's the language that was used, but we know that's not what they meant. And the question is, can we do the same thing here?
I believe you can, Your Honor, and I guess I think that the reason why it is appropriate for the court to conclude that's what the legislature meant here is, by analogy, if you look at the sexual offender registration statute, that's also an onerous requirement. But that also is a statute that the legislature has said applies to juveniles. There's a general scheme or a general intent, a legislative intent, I think, with respect to sex offenders to monitor and track.
Going along with that, if there is this sort of unified scheme, and there's a way for a judge in that context to relieve someone of the obligation to register because the judge makes a finding, they're of no risk to the public and they're of no risk of reoffending, why then wouldn't advancing the position that Justice Gantz is asking you to consider about what the legislature meant as a common sense matter here, why wouldn't this be something that would allow a particularized or a discretionary handling of the situation of a juvenile in these circumstances?
I think it's difficult to read that in the statute because it uses, into the statute, Your Honor, because it uses the word shall. And I think, and the Commonwealth would concede, that the statute can be criticized because it doesn't allow for that exercise of discretion. But I think it's difficult to read a discretionary ability of a judge into the language of the statute, where the statute says any person placed on probation by reason of any designated sex offense shall wear a GPS monitor. It's difficult to read a discretionary application of that condition into that broad language that the legislature has used. I will say that when you apply this statute to juveniles, by definition, the period of monitoring is going to be briefer than it's going to be in many cases for an adult, because the probationary period can extend for a long period of time for an adult who's convicted of a sex offense, but by definition for a juvenile, the period of probation is going to be comparatively short.
And you can also infer that the consequences on the person are probably going to be greater just because of the
age.
The age and the size of the body versus the size of the GPS.
I think there's a limited record here, Your Honor, with respect to the burden that's imposed. I mean, I think the court acknowledged in Canadian that technology changes, and that what actually happens with respect to GPS monitoring, what the equipment looks like, how visible it is, what kind of restrictions it places on somebody who's on GPS monitoring. Those things, perhaps have changed since this juvenile was placed on probation, perhaps will change. And the record's not really clear on the cases have described certain kinds of equipment, but technology does change.
Don't we have to assume that the legislature understood the technology as it was when it passed it? And
Yes, Your Honor.
that this is essential for a child, this is more than a scarlet A to be wearing to school each day, isn't it?
I don't know how visible. I mean, this child wore on other children. I mean, let me step back and say that in Emilio E., this court did say that a juvenile judge has the discretion, even prior to adjudication of guilt, to apply to use this kind of technology even prior to adjudication of guilt. I wanted just very briefly to say something about the constitutionality of the application, and that is that in Corey, this court described or referred to this statute as applying without regard to dangerousness. So the finding that a juvenile court judge makes in this case, that the person doesn't pose a danger to the public, that really doesn't differentiate this particular juvenile from other probationers to whom the condition applies. There's no individualized determination of dangerousness with respect to any probationer to whom this particular condition applies.
All right, counsel, thank you.
Thank you, Your Honors.